Hello, I'm Stuart Evans. I'm a partner in the commercial advisory team at BLM. Today, I'm going to look at the following question. What if my business is facing insolvency proceedings through creditor action? To answer this, we're going to have to break this down into two parts. Firstly, what we would call normal circumstances pre-COVID-19, and then how temporary measures may impact on this during the current pandemic. Here, we are going to focus on statutory demands and winding up petitions. So, starting with normal circumstances, if you are served with a stat demand, this is a gateway to winding up proceedings. You can't ignore it, because if you don't take conclusive action within 21 days, you will be deemed insolvent and a winding up petition will follow. If you owe the money claimed, you need to pay or compromise the debt. If you can dispute the debt on substantial grounds or have a cross-claim, then you can seek an injunction preventing a winding up petition being issued or advertised. Getting undertakings from creditors not to take further action unless they give adequate notice may sometimes be appropriate and preferable, as injunctions are expensive. If you are served with a winding up petition, you need to act fast, as there is an immediate legal consequence. Section 127 of the Insolvency Act applies. This means that if the company eventually goes into liquidation, any transactions entered into between presentation of the petition and liquidation are void, unless they are otherwise approved by the court. You should therefore start to consider whether you need to apply to court for a validation order and start gathering the material for that application. That evidence will either need to show that the company is solvent or that the transactions that you are proposing are for the benefit of the company's creditors as a whole. If you dispute the debt claimed in the petition or that you are insolvent, then again, you can seek an injunction restraining advertisement of the petition. Otherwise, the creditor will advertise the petition in the London Gazette. It is often this step which brings the practical consequences of the petition, with bank accounts being frozen and so on. You will need to satisfy the court that there is a genuine dispute as to the debt. If you can, you should encourage the creditor to withdraw the petition, but there won't be much time to do this. The other thing to bear in mind is that creditors are like commandos crawling through a net. There may be more than one of them which is active. So, if you resolve the petition with the creditor, but other creditors have heard about the petition and want to support it, the petition, once in progress, can take on a life of its own. Insolvency is a class remedy, and the first hearing of the petition is listed when it is presented. That hearing will allow any other creditors to come forward and seek substitution as petitioner. This hearing will happen unless the petitioner agrees to withdraw the petition. That can only happen with the court's consent if it has not been advertised, no supporting creditors have contacted the petitioner, and you consent. Now, so far, we have looked at how difficult it can be to turn the tide unless you act quickly. Whilst you may be able to resist creditor action, you must take a step back and evaluate whether such pressure may be sending you a message about the solvency of your business. This could be a wake-up call. If your business regularly cannot pay its bills, particularly if that was already the case before the current crisis, then you need to take advice from an insolvency practitioner. It may be that you can agree a restructuring plan that works for you, or a voluntary arrangement with your creditors, using the moratorium option contained in recent legislation. Alternatively, it may be that administration is the right course, or if liquidation is inevitable, there may be an advantage in you taking things in hand and seeking a creditor's voluntary liquidation rather than allowing the company to go into compulsory liquidation as a result of creditor court action. So, what are the temporary measures that I mentioned at the start? At the moment, we are in different territory. Under recent legislation, stat demands served between 1st March and 30th September 2020 cannot be used as the basis for presenting a winding up petition after 27th April 2020 and will therefore effectively be void. In addition, creditors cannot progress a winding up petition until the end of September 2020 unless they can show that the debtor's insolvency is not related to COVID-19. These dates may be extended further. Still, creditor insolvency action should and must be taken seriously, as it may be a symptom of your business. So if you're facing claims or are concerned about the state of your business, act quickly and get professional advice early on, as difficult situations can often be turned around. We have covered various matters in our What If series in broad outline. Each business is different and each matter turns on its own unique facts. So if you have any further questions or need specific advice, please do get in touch using the details at the end of this video. In the meantime, stay safe and thank you for watching.